Hi, y'all, and welcome back. If you're new here, welcome and glad you found us. I am JoJo, and it is great to meet you. We are about to talk about another true crime case and hopefully see justice be done. But before we do, please hit that like button. And if you haven't already, click subscribe and turn your bell notifications to all so you can make sure to be notified when I post new videos. Thank you, everyone, for all your support. It means the world to me. Now sit back, kick off your shoes, grab your tissues and stress balls, and let's dive in. The content you are about to watch contains the subject matter of a real-life true crime event. Therefore, it is not suitable for all ages and is only intended for adults. Hi, y'all. It's still Monday, and it's still morning, actually. I'm surprised. Welcome back. If you were just in my last video, I went over the oldest case. Now we're going to go over the second criminal case in his criminal record, and this is actually a traffic offense. It's a misdemeanor, and he actually did receive probation on this one as well. There is 3 different cases, so originally I was going to do all 3 cases in one video. After seeing how long it took me to do just the first case record, I've decided that we're going to break these down and do one video per case record. This is case record number 2. So this one here is in the County of Riverside. The ordered bail was only $5,000. The arrest date on this one was March 29th, 2019. The filing date was April 23rd, 2019. And in this particular one, there was 9 continuances. The first charge is willful resist delay obstruction, which is a misdemeanor. He pled guilty and he was convicted. Second offense, improper turn from left lane. That's why I said this is a traffic offense. Infraction, guilty, convicted. And then he also refused to present his driver's license to the officer, which is another misdemeanor. He pled guilty and he was convicted. His upcoming hearings are for 2 other cases. It has nothing to do with this case in particular because this case is already closed. But the 2 other cases, they have hearings coming up on September 2nd, 2025. So that's about 2 weeks out from today. One of them is for violation of probation and the other is for a trial setting conference, and they're both set at 8:30 a.m. So I guess they're going to just combine the 2 cases into one hearing. What I like to do is we're going to go all the way down to the bottom of this document now, all the way to the very last page, and then we're going to work our way up because the infinite wisdom of these people, they decide to put the oldest date all the way down at the bottom. April 2nd, 2019, bail bond is filed, an appearance date is set for May 8th, 2019, and the bond was posted for $5,000 on the same exact day, and then he was released on the bond, and appearance date again is for May 8th, 2019. April 23rd, 2019, electronic complaint filed. May 8th, 2019, this is when he has his arraignment at 7:30 a.m. Defendant advised of the right to have matter heard before a commissioner or judge by posted and verbal notice. Defendant is deemed to have stipulated to temporary judge pursuant to CRC Rule 2.816. Court has read and considered financial report. Court orders defendant's financial statement and notice to defendant filed. Public defender appointed. Defendant represented by DPD Jennifer Mullins. Defendant present. Defendant's counsel waives formal arraignment. Counsel for defendant waives formal reading of complaint and stipulates defendant has been advised of his or her legal and constitutional rights. Pleads not guilty to all charges. Trial readiness conference set for June 17th, 2019 at 8:30. Defendant waives time for trial to 6/17/2019 plus 45 days. On 5/8/2019, request for continuance filed. 5/8/2019, defendant's financial statement and notice for defendant filed. Confidential. So California doesn't let you see those records. Now, I live in Florida. They let you see those records. records. And you know what else Florida does? They don't make you pay for these documents like California does. I had to pay for this one. 6/17/2019, trial readiness conference at 8:30 a.m. Defendant present. Oral motion by defense regarding continue the matter is called for hearing. Defense motion to continue pursuant to 1050 PC is granted. Motion to continue is not opposed by the people. Hearing continued to July 15, 2019 at 8:30. Continuances. Gotta love them. The court finds good cause has been shown. Grant the continuance. Reason for continuance. Other. I hate when they do that. I mean, why can't they just put the real reason why they're doing the continuance? Defendant waives time for trial to July 15th, 2019 plus 45 days. And then, of course, on 6/17/2019, request for continuance pursuant to PC 1050 filed. And 7/15/2019, trial readiness conference at 8:30. Defendant is not present. Bail bond is forfeited. Bench warrant issued for failure to appear. Bail set at $5,000. Now, why was it only set at $5,000? I thought that when you end up skipping out on bail, that they end up raising your next bail. So once they do catch you, your next bail is going to be even higher because now you're considered a flight risk if you skip out on bail the first time, which he ended up doing in the other document. Just a little teaser that you might want to go check out the other document because he did skip bail on that one once. And 7/15/2019, notice of bail bond forfeiture filed. And then right here, 7/15/2019, bond forfeited. 7/16/2019, DMV direct update FTA hold issued. FTA. I wonder what that is. Maybe one of y'all can help me out down there. It's F as in Frank, T as in Tom, A as in Apple. Do any of y'all know what those letters stand for in this context? Maybe y'all can help me out. Put it down there in the comments, please. 7/16/2019, electronic warrant sent at 10:38. And then on 7/30/2019, warrant trial readiness conference at 7:30 a.m. Bench warrant recalled. Reason appeared in court. So he decided to make an appearance. Defendant is present. Oral motion by defendant regarding reinstate bail bond is called for hearing. Motion petition granted. Bail bond reinstated. Bail forfeiture is ordered vacated. California seems to be rather lax. Or is it just this case? Or I should say this person that they seem to be rather lax with? Because you'll see on my prior video where I go over the first case record, once you go through that video, he essentially got a slap on the wrist on that one. And in my opinion, they were rather lax on him there too. California just seems to be a little lax on what I'm reading. This is the first case that I'm covering out of California. But let's just say I'm not really impressed so far. Court cost of $100 imposed for the setting aside of the forfeiture on bail bond is payable by 8/29/2019, 8:30. Trial readiness conference set for 8/29/2019 at 8:30. Defendant waives time for trial to 8/29/2019 plus 45 days. And then 7/30/2019, warrant recall requested. Warrant was recalled successfully. And then on 8/1/2019, request for continuance pursuant to PC 1050 filed. 8/1/2019, notice of bail bond reinstatement filed. 8/23/2019, electronic amended complaint received. Why did they amend the complaint? I really wish that they would have given me the option to be able to get some of these docs. I mean, I would have been willing to pay for them, but they didn't even give me the option to get any of them. 8/27/2019, payment of $100 received. 8/27/2019, payment for bail bond cost imposed to set aside forfeiture. 8/29/2019, verify court costs paid on bail bond. August 29, 2019, trial readiness conference at 8:30. Defendant is present. Oral motion by people regarding amend complaint to add count 3 is called for hearing. Motion petition granted. Okay, so the amendment was to add the third count. Complaint is orally amended to add count 3, a violation of section 12951B. Defendant's counsel waives formal arraignment. Counsel for defendant waives formal reading of complaint and stipulates defendant has been advised of his or her legal and constitutional rights. Pleads not guilty to count 3. Of course he does. Defense motion to continue pursuant to 1050 PC is granted. Motion to continue is not opposed by the people. Hearing continued to 10/1/2019 at 8:30. Reason for continuance. Other. Didn't see that one coming, did ya? Defendant waives time for trial to 10/1/2019 plus 45 days. And then, of course, the request for continuance was filed on 8/29/2019. First amended misdemeanor complaint filed 8/29/2019. Hearing set 8/29/2019 at 8:30 for CCBB is vacated with CCBB. Not exactly sure what that is. So let's see. We're up to October 1st, 2019. Trial readiness conference at 8:30 a.m. Defendant is present. Oral motion by defense regarding continue the matter is called for hearing. Defense motion to continue pursuant to 1050 PC is granted. Motion to continue is not opposed by the people. Hearing continued to November 5th, 2019 at 8:30. Reason for continuance. Other. Did you see that one coming? Did you? Defense waives time for trial to November 5th, 2019 plus 45 days. Request for continuance on 11/1/2019 was filed. And then October 22nd, 2019, motion to suppress evidence was filed. On October 25th, 2019, opposition to motion to suppress evidence was filed by the DA. And here we are on November 5th, 2019. Trial readiness conference at 8:30 a.m. Defendant is not present. Current bail bond forfeited. Bench warrant issued for failure to appear. Bail bond set at $5,000. Okay, explain this to me. Make this make sense. This is the second time now that he's jumped bail. He didn't make his court appearance. Yet they continue to keep setting the bail at the same amount of $5,000. Why? Please, make it make sense. The math is not mathing here to me. This means he's a flight risk. He's not showing up to his court appearances when he's supposed to. I mean, one time, okay, a fluke, but now 2 times, and yet you're still going to set his bond at the same amount? Obviously, $5,000 is not a big deal to him. And then you're just going to probably go and reinstate it again. So technically, he's not losing anything. You're slapping him on the wrist again. I don't understand it. I just don't understand it. Make it make sense, California. Moving on. That hearing was the same day as the trial readiness conference. And it was at the same time, too. So I guess they were doing the 2 hearings together. Defendant is not present. Of course he's not. Hearing taken off calendar on court's own motion. Motion/petition granted. Bench warrant remains outstanding. And then 11/5/2019, bond forfeited. Notice of bail bond forfeiture filed. Electronic warrant sent at 10:36 on, and that was done on 11/6/2019, not on 11/5, which why did they wait till the next day to send the warrant? That doesn't make any sense. You would think that they would send the warrant on the same day that he failed to show up in court. 11/21/2019, warrant trial readiness conference. November 9th, 2019, warrant/trial readiness conference at 7:30 a.m. Defendant advised of the right to have matter heard before a commissioner or judge by posted and verbal notice. Defendant is deemed to have stipulated to temporary judge pursuant to CRC Rule 2.816. Wow, he showed up. Defendant present. Bench warrant recalled. Reason appeared in court. Oral motion by defense regarding continue the matter is called for hearing. Motion/petition granted. Trial readiness conference set for January 31, 2020 at 8:30. Jury trial set for February 21, 2020 at 8:30. Time estimate for jury trial is 3 days. Last day for trial to commence is March 1, 2020. Court has read and considered bail bond reassumption letter. Bail bond reinstated. Bail forfeiture is ordered vacated. They did it again. A slap on the wrist. Again. All he's having to pay is $100. He paid $100 $100 last time, and he's paying $100 again. So he lost $100 last time. He's losing $100 this time. A slap on the wrist, California. Why? Court cost of $100 imposed for the setting aside of the forfeiture on bail bond is payable by January 31st, 2020, 8:30. Notice generated. Court cost imposed. Defendant ordered to return on any and all future hearing dates. I mean, it's like a little kid. He puts his hand in the cookie jar. You slap his hand. If he's not getting a real punishment, then he's going to continue doing it. 12/9/2019. Warrant recall requested. 12/9/2019. Bond reinstated. 12/9/2019. Request for continuance filed. 12/9/2019. Notice of bail bond reinstatement filed. 12/9/2019. Notice of court cost imposed. 12/9/2019. Reassumption of liability as to bail bond filed. 12/9/2019. Warrant was recalled successfully. December 31st, 2019. Payment for bail bond cost imposed to set aside forfeiture. And then 12/31/2019. Payment of $100 received. 12/31/2019. Hearing set. 1/31/2020 at 8:30 for CCBB is vacated. So CCBB came into play again. We've really got to figure out what cat boy boy stands for. It's got to be something to do with the bond. That's the only thing I can think of. All right. January 14th, 2020, case updated on DMV, online update, 1/14/2020, warning, turn off the reporting on 595. Okay. I'm not quite sure what that's supposed to mean. Alrighty then. 1/31/2020. Verify court costs paid on bail bond. And then January 31, 2020. Trial readiness conference at 8:30. Defendant advised of the right to have matter heard before a commissioner or judge by posted and verbal notice. Defendant is deemed to have stipulated to temporary judgment pursuant to CRC Rule 2.816. I'm going to end up repeating all this stuff in my sleep by the time I'm done reading all of these because it seems so repetitive. Oral motion by defense regarding set 1538 motion is called for hearing. Hearing regarding motion to suppress evidence pursuant to 1538.5 PC set 1/31/2020 at 10 a.m. All parties ordered to report to B302. Defendant ordered to return on any and all future hearing dates. And we're on page 6. We're getting there. This one was 14 pages long total. So, hearing regarding motion to suppress evidence pursuant to 1538.5 PC at 10 a.m. At 10:44, the following proceedings were held. Defendant was present. Maybe he's starting to learn his lesson. Do you think? I don't know. Court has read and considered motions as submitted by counsel. The court states its intention is to listen to evidence and arguments of counsel and finish reading the motions and give counsel a ruling at that time. At 10:47, the following proceedings were held. People's witness, Takesha Nishida, I hope I got that right, is sworn and testifies. Witness Takesha Nishida is excused. Defendant's witness, Jake Haro, is sworn and testifies. Court and counsel confer regarding people's position regarding designation of officer. Officer Nishida designated as investigating officer. Witness Jake Haro is excused. Both counsel rest. Argument by defense heard. Argument by people heard. The court inquires of both counsel. Court in recess at 11:26. At 11:39, the following proceedings were held. The court resumes the hearing. All parties are present. Matter and evidence submitted is taken under submission. Trial readiness conference set for February 7, 2020 at 8:45. Current bail bond continued. Okay, so that really didn't tell us much of nothing now, did it? I'd like to see the transcript on that. So 1/31/2020, hearing set for February 21st, 2020 at 8:30 for JT is vacated. JT, jury trial, maybe? Yeah, because I think he did have a jury trial on this particular case. So that's probably what that's for. That's probably for a jury trial. That would be set for February 21st, 2020, but it says it was vacated. You know what? Maybe I should start doing some lives, because then you guys could actually talk back to me and we could have a conversation. All right, so February 7th, 2020, ruling on matter submitted on January 31st, 2020 regarding 1538 motion at 11:30 a.m., which the 1538 motion was the motion to suppress evidence. And so at 9:23, the following proceedings were held. Defendant present. Oh, he's actually showing up to all his court dates now. Yay for the defendant. Court subsequently rules on matter taken under submission on January 31st, 2020. Court has read and considered motions as submitted and evidence presented. Oral motion by defense regarding request court review police manual is called for hearing. Argument by both counsel heard. Motion/petition denied. The court states this matter is closed to evidence and does not feel reading the manual will change the court's position on the matter. 1538.5 Penal Code motion is denied. Okay, I'm a little bit confused. So they were wanting the judge to read the police manual? I'm a little confused on why they would want the judge to read the manual. We're gonna move along up. So on February 7, 2020, trial readiness conference at 8:45 a.m. Oral motion by defense regarding request to set case for trial is called for hearing. Motion/petition is called for hearing. Motion/petition granted. Jury trial set for February 21st, 2020 at 8:31. That's an odd time to set for a jury trial. 8:31? Why not just set it for 8:30? Time estimate for jury trial, 3 days. Last day for trial to commence is March 2nd, 2020. And then current bail bond continued. February 21, 2020, jury trial. So now we're going to get into the jury trial. Hopefully we have some actual good details in here. I doubt it, but one can hope, can I? And this is page 3, so we're almost done with this document. February 21st, 2020, jury trial at 8:31 a.m. I still think that is ridiculous. Why set it at 8:31 a.m.? Anyway, moving on. Okay, defendant advised of the right to have matter heard before a commissioner or judge by posted and verbal notice. Defendant is deemed to have stipulated to temporary judge pursuant to CRC Rule 2.816. Defendant present. Hey, at least he showed up for his jury trial. That's a good thing. That's always a good start to the jury trial. Defendant withdraws plea of not guilty as to counts 1, 2, 3 and is rearranged. Misdemeanor plea form is incorporated herein and includes the following advisements and waivers. So they go and show up at the jury trial and he changes his plea. Alrighty then. Why not do that sooner, dude? Okay. Defendant advised of right to a speedy and public trial by judge or jury. Defendant advised of right to confront and cross-examine witnesses. Right to present evidence on own behalf. Defendant advised of right to ask court to compel witnesses to attend trial at no expense. Defendant advised of right to have a court reporter at all proceedings. If I cannot afford one, court will provide one at no cost. I didn't know that you had to supply your own court reporter. Wow, California really is money hungry. Defendant advised of privilege against self-incrimination. Defendant advised of right to counsel. Continue to consult counsel. Assignment of counsel if unable to employ private counsel. Defendant advised that she will be required to pay restitution fine of not less than $100 and not more than $1,000 if convicted. Defendant advised of restitution hearing rights. Defendant advised if not a citizen, conviction may result in deportation, exclusion from admission to this country, or denial of naturalization. Defendant advised of charges and consequences of his or her plea, and statutory sentencing. Defendant advised of constitutional rights. Defendant waives constitutional rights. Defendant waives right to trial by jury. Defendant waives right to confront and cross-examine witnesses. Defendant waives right to ask court to compel witnesses to attend trial at no expense. Defendant waives privilege against self-incrimination. Court finds based on inquiry and examination of defendant that defendant has the ability to understand and does understand his or her constitutional rights. Court finds defendant's admission of guilt and or admission of prior convictions and or probation violations, if any, is the result and product of the result of the defendant expressly, knowingly, understandingly, and intelligently waives his or her constitutional rights, including but not limited to right to counsel, privilege against self-incrimination, to trial by jury, and to confront accusers, and voluntarily made with an understanding of the nature and consequences thereof. Defendant's waiver of constitutional rights taken orally and or in writing. Defendant pleads guilty to counts 1, 2, 3. Defense counsel concurs in defendant's plea and or omissions. Court finds plea is free and voluntary. Court finds defendant knows and understands constitutional rights, nature of charges, and consequences of plea. Court accepts plea. Defendant waives arraignment for pronouncement of judgment. Defendant requests immediate sentence. No legal cause why sentence should not be pronounced for the charges 1, 2, 3. Proceedings are suspended. Summary probation granted for a period of 36 months on the following terms and condition. Okay, so he got 36 months. Is that okay? Never mind. We'll keep reading and I'll probably get my answer. Okay, so summary probation. Or is that supposed to say summary probation granted for a period of 36 months on the following terms and conditions? Obey all laws, ordinance, and court orders. Be committed to the custody of the Riverside County Sheriff for 10 days. Credit for time served pre-sentence of 2 actual days plus 2 days pursuant to 4019 PC for a total of 4 days. 6 days to be served in the work release program. Report on or before April 21, 2020. Referral notice generated. RSO work release. As to counts 1, 2, 3, court operations assessment fee of $40 imposed for each convicted charge. Pay conviction assessment fee for the following convicted counts 1, 2, 3, $30 each, misdemeanor and felony. Pay booking fees of $514.58. Pay restitution fine of $150. Pay $150 for probation revocation restitution fine. Said restitution fine is stayed, and the stay shall be lifted upon the revocation of probation, and if the defendant is sentenced to prison or county jail without a probation or conditional sentence imposed. Set payment date for May 21, 2020. Court finds that the defendant has the ability to reimburse the county for attorney fees in the amount of $50 payable to the court through ECD, Edward Cat Dog, not quite sure what that means. Electronic check deposit, maybe? Do not annoy, harass, threaten, or disturb the peace of Sergeant Nishinda of Hemet Police Department. I didn't know that they actually had to put that in there. Defendant accepts terms and conditions of probation. Current bail bond exonerated. Released on probation. 36 months is all he got in total for all 3 counts, I take it. At least that's how I read it. Let's go down here to the probation notes real quick. Wait. No, that's not it. Okay, so probation summary. Date granted was February 21, 2020. Expiration date, February 20, 2023. Really? That's rather interesting. So that would kind of explain why they kept doing the continuances on the prior case, which is in that prior video that I was talking about when I started this video. Because, well, I don't know. Would that probation be just for... No, it wouldn't be just for traffic violations, I don't think. Because it says obey all laws, ordinances, and court orders. So right here, obey all laws. Okay, so to me, that would mean even criminal laws, not just dealing with traffic offenses. That would mean any laws. And on his prior charges in the video that I just got done doing, he started his probation on June 8th of 2023. And they were constantly doing continuances on that case. So now that kind of answers my question, is they were putting off that court. And this is just my opinion, and it's a theory that I'm throwing out there, that I believe that they were putting that off because of the fact that he was still on probation for this case here. So basically, he was getting off of one probation going into another probation because he was arrested for that prior charge on October 12th, 2018. So he was actually, that's real funny. He was arrested for the first charge, the first case, prior to this case. Yet this case came to a conclusion before that case, and he got probation for 2 years on this one. But see, the prior case wasn't actually filed until October 5th of 2021. And when was this one? This one was filed before that. So he actually went to court on this one before the other one was actually filed, even though he was arrested prior. Boy, this guy just, oh my gosh. Oh my Lord, poor Emmanuel. Where are you? Where are you, you precious little thing? Man, I just can't even imagine what he's went through in his short little life. Let's move back on up here. Where were we? Okay, there's the jury trial right there. Okay, so we're back where we need to be now, and basically this is back at the beginning, so we're almost done with this case here. So for February 21st, 2022, the bond is exonerated, and the misdemeanor plea form is filed. The notice of the bail bond exoneration is filed. Sentence memoranda is filed. The electronic 8715 disposition is generated, whatever that may be. My mistake. That was actually done on February 25th of 2020, not the 21st. And then on February 26, 2020, DMV direct update release issued. April 24th, 2020, date to pay extended due to COVID pandemic, which that I understand because that was like right in the middle of the whole pandemic and it just getting started and everything. And then June 9th, 2020, proof of completion of work release program filed. September 10th, 2020, payment of $465 was received. November 13th, 2020, payment of $254.58 was received. And then on November 19th, 2020, payment of $210 was received. And then I guess this is where it was closed. March 29th, 2021, bail bond number is to be addressed by 3/29/2021, which is 2 years from effective date of 3/29/2019. And that's the last thing that they have on this record. So we are done with this record now. And I'm going to go ahead and get the last case record video done. And then I will be actually done making videos, at least for today, being that I am approaching noon and I do have other things that I really have to get done today. If you go ahead and follow along with me on to the next video, or while you're waiting, why don't you go ahead and put down your thoughts down there in the comments so far, or if you haven't already, go ahead and take a look at my first video that I ended up doing. And don't forget to, just to make sure that you do get notified once the new one gets put up there, make sure that you got your bell notifications selected to all. I will catch you all in the next video. And thank you so much for your support. But if you're not able to get into the next video today, y'all have a great rest of your day, and I will catch you later. And until then, be safe, be happy. Bye-bye now.